Now over to you, Sidharth. If you can throw some light on, again, the bottleneck before we move on to the second part, and what has been your practical daily living experience as a practitioner?
Thank you, Rohan. Esteemed members on the panel, ladies and gentlemen, namaste and a very good morning to all of you. We as practitioners frequently witness commercial disputes getting delayed owing to procedural complexities or backlogs, and disputes getting dragged on for years even before commercial courts. So my experience has been that to address this, clients today have become far more strategic and innovative when it comes to how they manage and approach their disputes. There is a clear shift in business strategy, with settlements becoming a more viable alternative. Today, the dominant client mindset is not legal ego. The dominant client mindset is business continuity and consistency. The primary concern is not legal entitlement, but how a dispute impacts their operations, cash flow, and reputation. When clients come to us, they now want an upfront viability assessment. They want to know as to what a dispute will be in terms of, or will have an impact on their time, cost, operations, and what will be the realistic outcome. And based on an evaluation of this viability assessment, they then decide whether to litigate or not litigate at all. And as a consequence, in my experience, weak or smaller value disputes often get parked or get settled at an early stage. Even in cases of higher value disputes, there is an increasing inclination and desire to opt for pre-litigation mediations. Clients are much more receptive to that today. Coupled with this is the fact that clients today want predictable billing. These are all practical scenarios that I'm trying to throw some light on. Clients want practical billing. Litigation is seen as a project with defined deliverables and budgets. And to budget for long pending litigations, clients approach law firms and request for well-defined fee arrangements, fixed fee arrangements, instead of long hourly, open-ended hourly billings. And to cater to these demands, even law firms are very proactive, and we are very happy to provide for fixed fee arrangements and not hourly billings in all the cases. Dispute resolution mechanisms are also today chosen strategically. Many businesses are proactively opting for arbitrations and mediations, and there is a clear desire to move away from courts, as Kritika mentioned. Institutional rules and arbitration seats are also chosen strategically. The guiding question today is, in the mind of every client, how will I get the most effective outcome to a commercial dispute? Sasta, Badhiya, Tikau, or Tez. No client today wants to be in a situation where bhais bik jaye aur bakri na mile.
Thank you, Sidharth. So Sidharth, quick comments.
Yes, Rohan. So this is more for my younger colleagues in the audience. The future of commercial disputes belongs to lawyers who think like risk managers and negotiators first and litigators second. There is a need for a change in mindset. Lawyers must reinvent themselves from being post-dispute firefighters to people who are enabling and facilitating settlements. Lawyers ought to guide their clients that delay is not a leverage. The old playbook of file, adjourn, and settle later does not work any longer when clients are bleeding money awaiting resolution of disputes. Conducting a genuine cost-benefit analysis at the very start of a litigation goes a long way in guiding your clients and hand-holding your clients. Lawyers must identify and flag potential dispute triggers and advise their clients in safeguarding and providing for structures that minimize disputes. Dispute avoidance should be the key today. Lawyers should ensure that the contracts provide for strict timelines, clear exit mechanisms, enforceable ADR clauses, boilerplate arbitration clauses which are mechanically inserted at the end of a document without any thought have to be done away with. The standard clauses that we put in the arbitration, in any agreement, have to be stress tested against real world situations. How will they operate if the courts are congested or where an arbitration, etc., arbitration seat is not functional, etc. And one last thought, technology is the key. Clients want speed, efficiency, and transparency, and not necessarily the old traditional courtroom craftsmanship. So therefore, lawyers have to be tech savvy, data savvy, technologically literate, evidence-based, AI-based assisted evidence management, e-hearings, e-filings, etc. are the future. So lawyers all need to be equipped with that. So those are my 2 cents.